This is a hunger strike for our property rights. My name is Aida Fernandez, and I own 7.5 acres in an area known in South Dade as the 8.5 square mile area. It should be clear to everyone, most importantly to our government on all levels, the property rights, first and foremost, are our human rights. The Constitution was made to protect our natural rights, which are life, liberty, and property. I feel that all of them have been violated in the worst, most despicable way by DERM. The issue is complex, but we will try to keep it short to see if you're interested in this story of a farming community that have had their lands and home here for the past 40 years. We're a community located in the 8.5 square mile area in Miami Dade County. The government already has taken half of the 8.5 square mile area for the so-called Everglades Restoration Plan. Now South Florida Water Management, together with DERM, Miami Dade County Department of Environmental Resources, are totally ignoring Public Law 108-7 that was approved and signed by Congress in 2003 at a cost of $300 million to protect and promote agriculture to the remaining residents, property owners, by giving them flood protection qualifications which would have brought about the rezoning of the community. In 1989, Congress passed Public Law 101-229. This act ordered the Corps of Engineers to restore a more natural hydrologic regime to the Everglades National Park and to protect the people who were impacted by this project, which is this area. The Corps developed the Modified Water Delivery Project to do this. The project consisted of structures to allow more water to flow under the Tamiami Trail and into the park, protecting the Miccosukee Indian Camp and providing flood protection for a small minority farming community, which is this area, the 8.5 square mile area. The project was supposed to have cost $81 million and be completed by 1997. It is noteworthy to mention that the 8.5 square mile area does not sit on top of the Shark River slough, nor does it obstruct in any way the natural flow of water to the Everglades National Park, Florida Bay, nor the Miccosukee tribe of Indians are affected negatively by it. Rather than provide the flood protection to the whole farming community at a tag of $81 million, the Corps decided to condemn and destroy 1/3 of the community and construct a different project component. Residents took the corpse to the federal court and won. The judge ruled that the corpse did not have the authority to condemn the land outside the footprint of the original authorization, which is they took alternative D. However, the congressional language granting them the authority stated that they were being allowed to do this in order to provide flood protection, very clearly, not mitigation, for the remaining minority farming community and residents in the area. The project has been completed by the Corps at this time, providing a levee, a seepage canal, and a pump station, which is the S-357. The S-357 controls the newly constructed seepage canal within the remaining 8.5 square mile area. This pump station has 5 pumps within the building at a cost of approximately $400 million so far. This means that the federal government has subsidized to the tune of approximately $400 million to date the rock mining industry here in South Florida. Because of the government claiming that there will be no flood protection granted to the area, Miami-Dade County DERM is attempting to force people off their land with outrageous fines, allegations of permit violations, coercion, and judicial persecution. Hence, creating the abandonment of properties due to the financial bankruptcy endured while trying to defend their property rights, not to mention the devaluation of the property located here. This is a list of all the sightings that I've had in the 11th Judicial Court and how much they made me gone to court. This is a very long list. This is what I call judicial persecution. Note, DERM is not enforcing eminent domain. Instead, they want for property owners just to abandon their properties, remove all the soil to the coral rock, continue paying for the mortgages, continue paying for property taxes, and just let it revegetate, or suffer the consequences brought on by the dictatorial powers over this small community. For what? To have our land used as a dump site for garbage and debris, horse slaughtering haven, not to mention invasive species of plants and animals invading our private properties. Here are my issues and questions. Number 1, If indeed the property were designated wetlands, why weren't owners informed and notice given via certified mail and placed as required by real estate laws in their deed and title? Public hearing for zoning changes were not announced. People needed to be informed before the selling or buying of these lands. Why does DERM, number 2, why does DERM openly state that they did not disclose it on title or gave notice because this would have devaluated the property values and they could have gotten sued back in 1999? Why the interest now? Is it because the rock miners, cement companies are running out of land on Chrome Avenue and 88th Street Southwest? And DERM is looking forward to getting these monies for permits to excavate and take out the fill from our properties? DERM depends on fine, fees, etc. to survive, and rock miners pay a lot of money and hefty fees to dig out our soil. Makes one wonder just how interested are they in preserving the environment. Follow to come to the determination of a property being a wetland. DERM determines if you're a wetland by a drive-by site inspection or helicopter ride inspection. Please note that this has been stated by DERM in several hearings held in the 11th Judicial Court System. Definitely not a legal way to delineate wetlands on any government level. Why do they say that we are 6 months of the year under the water? We have more flood protection than any one neighborhood in Miami-Dade County. We have a levee, 1 seepage canal, 1 Burroughs canal, and 2 pump stations in less than 5 square miles. We only get flooded when South Florida Water Management do not open the gates and or refuses to turn on the pump stations. In this community, everyone is scared to come out and face DERM. They are too scared to speak to one another even. I am scared too. I have been hit so hard and so furiously that I'm about to be stripped off of the patrimony that I could leave my children and grandchildren. That is my land. It should be noted that when freedom, which you used to enjoy, is prohibited by government, you have lost that freedom and the government has just gained power. When the government stops you from producing in your property, governs your actions and your uses, strips you of your hard-worked money, efforts, you have lost that freedom. Thomas Jefferson said once, when people are afraid of the government, that is tyranny. When government fears the people, that is democracy. Therefore, due to the severity of the harassment, judicial persecution, extortion, and so forth, I am requesting an investigation to be opened by the U.S. Attorney's Office for an impartial grand jury to be impaneled on DERM's action on the 8.5 square mile property owners and residents. Thank you. The signs that you have seen represent my hunger strike. I urge you to join me. Join me in my cause. If you live here or even outside of Florida, this might be happening to you. I am defending my property rights. This is my land. I have 7.5 acres. So please, I urge you, come and join me. If you need the directions as to how to get to the property, please look into our website, www.mylandgrabbyderm.com, and the directions are there. If you need to call, also please, you're welcome to call. If you cannot come and you cannot join me, at least please I urge you to call your commissioners. I will be in live feed all the time and you can chat with me on the webpage. Thank you.